After pleading guilty to the murders of 4 University of Idaho students in 2022, Bryan Kohberger is headed to an Idaho prison where he will spend the rest of his life. His plea deal came as a surprise just days before the trial was supposed to begin and was met with outrage from some of the victims' families because it allows him to avoid the death penalty. But is it really a surprise that he struck a deal? I'm criminal trial attorney Sara Azari, and this is Serving Justice, where we dig into what really matters in a criminal case, the defense. This week, we're going to break down why we should have seen this coming by looking back at some very high profile cases of the past, which also ended in plea deals that may have been shocking at the time. We'll also dig into some newly released documents from law enforcement and what they tell us about the case that Kohberger would have faced had he stood trial. Joining me now is NewsNation's Safia Samee Ali, who followed Kohberger's trial and his emotional sentencing hearing on Wednesday. Thanks for joining me, Safia. How are you?
I'm doing good. How are you, Sarah? Big day
Good.
yesterday.
I know, big day. So, Safia, this plea deal. I just want to talk about that first before we go back in history. How this all came together. The judge obviously didn't know. The judge just doesn't know until a change of plea is set on the calendar for the plea agreement to be filed, and then the change of plea to occur. But then the victims' families apparently didn't know either. They say they weren't consulted about the plea deal, and specifically Kaylee Gonzalez's father, and then her brother saying, Stephen, pointing out to what he called a troubling pattern of plea deals by this prosecution. Is this a covert operation that's specific to the Kohberger case, or is this sort of part of the course?
Well, I think that we actually got a little bit of a behind the scenes look yesterday. The judge lifted a gag order on people involved in the case. So prosecutors were actually able to talk to media yesterday. So they addressed this because the family has been, Kaylee Gonzalez's family has been very upset about this since it came out. And the prosecutors were saying that they were consulted. The families were told, they were consulted. Obviously, at the end of the day, it was up to the prosecutors. They made the decision based on the information they had, based on other factors, that this was the best choice. And obviously, Sarah, you know that at the end of the day, it's the prosecutor who gets to make that call, not the judge, not the families. It's the prosecutor. So as much, and with this case, the families were actually split. We had 2 families who were happy with the plea deal. They wanted the plea deal. They said that it was going to give them the closure. They were going to move on with their lives. They didn't have to deal with this very emotional, horrible trial. The other half, including the Gonzalez family, they were very upset and they wanted to go to trial. I think they were very convinced that he was going to get the death penalty and they wanted to see it through to the very end. They wanted to see this play out.
Well, and yeah, you're right. Victims, I guess it depends on how you define consultation. Consultation doesn't mean they get to endorse and bless the plea deal, or even approve of it. Consultation means really an advisement and hearing them out. They get heard about how they feel, their disappointment, why they think, this is not a good idea, etc. But ultimately, like you said, it's the call of the prosecution. There's a lot of factors that go into offering a plea deal to a defendant because there's a risk on both sides. There's a risk that you waste resources and he doesn't get the death penalty. That's a trial within a trial. On the defense side, there's a risk that they go to trial, he's found guilty, and he gets the death penalty. And then, of course, there's the consideration of wasting even more resources of Idaho State, which has already been a huge, made a huge dent for taxpayers to prosecute this case. And so remember, Kohberger has a public defender, has a lot of lawyers on his team. He has a death penalty lawyer. He has a lot of great experts. So it's a very costly prosecution. So there's a lot of factors.
And the prosecutor yesterday, Sarah, brought this up as well. And I think that's what part of the cost, because he said there were going to be 10,000 people who were going to be summoned for jury duty on this case. Imagine
in a small area.
Yes.
In a very small area. That's a lot of people. And so
the court staff, the amount of strain on the court, on the staff, everybody. I think that was sort of the hints that we were getting that went into this, that they were like, this is going to be huge, a huge,
And I always say there's always a chance. Prosecutors, even with this ironclad case that has DNA and all kinds of things, forensics, there's still a chance. There's a possibility of a mistrial. There's a possibility of jury nullification. There's all these different things. As you know, we've been covering trials on this show a lot. You have in your career. Things can happen, and so this is a done deal. He is spared death, but he certainly is not spared life. He spends the rest of his days behind bars. So, the families are often not happy about outcomes, but they don't get to call the outcome. They get to be advised. They get, they get the explanation, but ultimately it's not their call. So as the old adage goes, history repeats itself. So let's turn to history for a minute. Safia, you've combed through other cases where, a plea deal came as a surprise for one reason or another, where a defendant changed a plea. In one case, even minutes before the trial. What are some of these other examples that you have?
Yeah. Okay. I've got my notes ready for you, Sarah. Okay. Let's start off with Hunter Biden. Now, Hunter Biden entered a surprise guilty plea to 9 federal tax charges the day his trial was set to begin in September 2024. He was accused of running a 4-year scheme to avoid paying at least $1.4 million in taxes. Now, the interesting thing about this case is that he actually originally pleaded guilty. A judge rejected that plea. And so he changed that to not guilty, which put him on a path to trial, which was supposed to go through until the day of that trial. He changed the plea back to guilty. The judge was, the plea was accepted. And I think the reason behind this was because they just wanted to kind of clear the air for Hunter Biden and avoid what we all know would have been a very messy, very sticky public trial for the Biden family. Now, even though he pleaded guilty, he was never sentenced because he ended up being pardoned by his dad during his last days in office.
Yeah, I mean, he was one of the very few people that Biden pardoned. But, look, I think that prosecution overall was political. Yes, he committed offenses, but these were petty offenses. They became a huge big deal because of who his father was. And, prosecuting him, the nature of the charges, the decision to plead guilty, and then the judge not accepting it and then going back, all the back and forth, all of it was to some degree politically driven. And of course, at the end, you get a presidential pardon. It can't get more political than that, where your dad is pardoning you. So what else you got?
All right, we're going to move on to the BTK serial killer. So Dennis Rader, who's known as the BTK Killer, BTK stands for bind, torture, kill, which was the horrible, heinous way that this person murdered his victims. This is during the 1970s up until the 1990s in the Kansas area. He surprised many when he pleaded guilty to 10 counts of first-degree murder, also the day that his jury trial was set to begin in June 2005. Now, interesting thing about this case, after pleading guilty, he stood up and gave this very chilling, matter-of-fact allocution where he talked about where he did it, how he did it, why he did it. And, we rarely get that level of detail from defendants. And so this actually surprised prosecutors because they said prior to that hearing, they didn't have a plea deal in place with him. And he actually pleaded not guilty 4 months prior at his arraignment. So this kind of came at the time as a huge shock. He ended up getting 10 life sentences without the chance of parole.
So I've always wondered this. Maybe you have the answer. Did the prosecutors not know at that pretrial hearing that he was actually going to plead guilty?
It appears that they didn't. It looked like they were pretty surprised by this. I think that I don't know. Sometimes people who like serial killers, you just don't know. Like he not only did he plead guilty, but he just like
serial killers are unpredictable. Serial killers, yeah. I mean, maybe it is a serial killer pathology. I don't know, but it definitely was. It was supposed to be a pretrial hearing, and then he changes his plea to guilty. But what you brought up is interesting, because people always ask, he showed up and pled not guilty at the beginning of the case. That is standard. If a defendant goes to court and just pleads guilty at an arraignment, then they're pleading to the sheet. They've had no chance to defend themselves, exercise their right to trial, try to challenge the government's evidence and also the burden of proof. They're basically just throwing in the towel. So that is not the norm. It's rare, unless it's a petty offense. It's a misdemeanor. Defendant shows up to court. They're given diversion or something. You rarely see a defendant not plead not guilty at the beginning of the case. But, for a serial killer to do this on the day he's supposed to go to trial is also, I think, very shocking. But what you brought up about him just giving this very chilling, detailed account of his murders, the heinous murders that give him his, acronym BTK, we did not get that from Bryan Kohberger. I mean, we heard nothing. We heard no remorse. We heard no motive. And I think that's also why, Safia, the two families that are really upset, not just only that he's not going to get the death penalty, but that there's really no closure because there's been no testimony. They didn't get to really hear, what led him to this home to do this, and of course, we're all asking what was the motive. There was no clear motive according to law enforcement. So it's, to me also, I don't know how you feel about this, but it's also a confirmation that the defendant is not just guilty, but like guilty as sin, when they really kind of go through this whole rundown of what they were doing.
The motive question also, Sarah, I think so. When the lead investigators talked about the Kohberger in the investigation yesterday, they were asked point blank by several reporters, like, why? What was the motive?
Yeah.
They didn't have one. They didn't have one. And in fact, the lead prosecutor, the Latah County prosecutor, Bill Thompson, addressed this. And he said, they were like, why didn't you try to get a motive? Because I think, correct me if I'm wrong, you can use that as like, you can tie that into the plea agreement, right? Like you have to, can't you just say, can a prosecutor say, we will give you this deal, but part of this deal is you got to give up information about, why.
Sure.
Or is it,
they might ask for a proffer in the plea agreement.
Yeah.
Correct.
So now when asked that, Thompson said, basically, he's like, we didn't think that there was going to be any benefit in doing that because he's like, Kohberger is going to lie. This guy, you can't believe a word that comes out of his mouth. Anything that comes out of his mouth is going to be self-serving and it's going to end up hurting the victim's family in some way. He can say anything at this point, right? Make anything up. And that they were like, we're not going to touch it because you can't believe anything that he says.
But I think to your point, had they had evidence of motive, like social media contact or rejection by one of the girls or anything, I think then it would make sense to put that in the proffer and have him sign off on it, in the plea agreement that there's this proffer and that maybe even you should read it off in court, whatever the terms are. But because they didn't have that, leaving it open to him to come up with a story, I mean, I that's not really advisable.
Do you think, Sarah, since we're talking about it, because they had a lack of motive, that they saw that as a weak spot and that could have gone into the plea deal? Like, because that's what the jury's going to want to know. And it looks like they released a bunch of documents yesterday. We didn't find we still don't know. And they didn't,
Well, but see, motive is such an interesting thing because it's not an element of murder or any crime, but it's something that the jury always wants to hear. And at a trial, that would be the $1 million question is why would this guy kill 4 people? Like, what was his connection to any one of them? I mean, even if you said, I always thought the theory was that he went in targeting one person, but then the other people were around and you have to get rid of them, right? But where is that one connection? We just never got that. And apparently it didn't exist. Law enforcement didn't find it either. So at trial, that's another factor too, that I'm sure the prosecution is thinking like, we don't really have a motive to give this jury. I'm not saying that's like the deciding factor in offering a plea deal, but that is the $1 million question that every jury wants to know. So I think you also dug up the Highland Park shooter.
I did,
Okay, what is that about?
So Robert Crimo, who killed 7 and injured dozens at a July 4th parade in 2022 in Highland Park, which is a suburb outside of Chicago, he pleaded guilty minutes before opening statements for his trial in March this year, which obviously came as a huge shock because he previously pleaded not guilty and rejected a plea deal. So he ended up pleading guilty to 21 counts of first-degree murder and dozens of attempted murder charges. It was so shocking, Sarah, that his mother actually had an emotional outburst when she heard the plea because it came out of nowhere. And so the judge actually had to warn her to kind of, settle down because she kind of like reacted to this. So the judge ended up accepting the plea, and it stopped a trial that we know would have been weeks of testimony, evidence, all of that. He ended up getting 7 life sentences.
Wow. Yeah, Kohberger got 4. I mean,
Mhm.
one is pretty guaranteed that you're never going to see the light of day, but he's got 4 consecutive ones. But talk about like just at the nick of time, like right before opening statements. And again, you know, there's an incentive for both sides to enter into a plea deal. The defense runs a risk of being found, you know, the defendant being found guilty on all the counts, you know, and instead of pleading to maybe some of the counts in certain cases, and even getting more time. Because in truth, this is what I really want viewers to know is that the right to go to trial belongs to the defendant. That is the defendant's right to waive or exercise. But in truth, when you go to trial and you are found guilty by a jury, your punishment is going to be far harsher because the guy that sentences you has now heard all of the evidence. Now, in a case where you're dealing with a mass murderer or serial killer, I mean, that's pretty much kind of a done deal what the sentence would be. It's a question between life with or without parole and death and things like that. But in certain other cases, you know, like we just covered the Diddy trial, for example, you know, this judge heard how bad this man was and how bad he behaved. And so it's sentencing, you know, even though he's going down on prostitution charge, all of those bad things are going to get factored into his sentence. And, you know, he's going to get our sentence. So there is this absolute truth to the fact that if you do exercise your right to go to trial and you are found guilty by a jury, you lose that deal, which is either a lesser charge or a lighter sentence or whatever it might be that, you know, is an incentive that's offered by the prosecution, but not in
Well,
these
you know,
cases. These
Sara,
cases are pretty, pretty like black and white, but
I have a question for you. Since you're a defense attorney, do you, in your cases for your clients, do you feel like the closer the defendant gets to the trial, that's when like reality starts setting in more, right? Like when you're
yeah,
like years away, months away, you're just like, whatever, not guilty. But as you get closer and closer, because like some of these are days, the day of, the day before,
yeah.
you think it kind of reality hits them where they're like, I could be put away forever, or I could be, you know,
Mhm,
whatever you know, whatever they're pursuing. Do you think that
mhm.
at that point they're just like, oh my God, like this is actually happening? And then that kind of prompts them because it's like,
Yeah.
you're getting to that 11th
I think
hour.
it depends on the case, right? I mean, I've definitely had situations where it was really advisable for the client to take a plea and not go to trial because the evidence was overwhelming. And I would obviously give that's their right. So I would explain everything to them, pros, cons, chances, all that. And they would say, no, no, no. And then the day of, they're like, yeah, you're right. You know, I'm gonna take a deal. But there's also the reverse also works as well, is that sometimes the prosecutors are unreasonable and you've been telling them, look, you're not going to be able to meet your burden because of X, Y, and Z. When this person testifies, you're done. And they kind of, you know, huff and puff and whatever. They're arrogant about their case. And you just plow through and position yourself like you are going to go to trial. And then the trial date comes, you're about to select a jury, and they go, you know what, we're going to drop this and that. So sometimes it's a tactical,
Mm.
strategic
It's a game
decision.
of chicken.
Yeah, exactly. But with a lot at stake, obviously,
Yes, of
you know.
course.
Tell us about the 9/11 plotters plea deal. Oh my gosh,
Yeah.
what more about that?
So this
Uh-huh.
isn't much of a surprise, but I thought this was kind of a notable case surrounding plea deals. Really, really interesting. So in 2024, Pentagon officials reached a plea agreement with the 9/11 mastermind and some 9/11 plotters, allowing them to plead guilty in exchange for life in prison, which took the death penalty off the table.
Hmm.
Now, military prosecutors called the arrangement the best path to finality and justice. Now, a lot of families, victims' families, were very upset over this, and there were some outcries, and they were just not happy about it, which led then Defense Secretary Lloyd Austin to rescind the deal,
Hmm.
saying that the American public deserves the opportunities to see the military trial play out.
Hmm.
So now defense attorneys and the government went back and forth over this plea deal in the courts for a while. So the deal was on again, off again, on again, off again. And then finally, a panel of judges ruled this year that that Austin did have the power to rescind that deal. So now that entire process got kicked back into pretrial, and we're starting from scratch.
So, this was also another case that had politics involved in it as well. But I do want to just point out for me what sort of the moral of the story in this case is, Sophia, is that it is extremely difficult, if not impossible, to set aside a plea deal that you've not only entered into, but where you've gone to court and changed your plea, that the court has accepted your plea. I mean, you need to show judicial error, prosecutorial misconduct, hidden evidence, ineffective assistance of counsel, lack of discovery, or compromised state of mind when you did change your plea, something really tremendous to reverse it. It is very difficult to set aside a plea deal. And even if you do it before the court accepts the plea, you are then in breach of that agreement. So if down the road you change your mind and want to enter into another plea agreement with the government, they're not going to give you the same deal because you've breached your first agreement. So very interesting. But I want to bring in Rich Bodie, NewsNation producer, because he has some questions for us, Safia, on the Kohberger case. I hope we can answer it.
Yes, Sara, Safia, thanks for having me. I've been following the Bryan Kohberger case, as you both have, and I covered the Robert Crimo III case as well. But I have to say, Wednesday raised a lot of questions for me, and I think many of us without a law degree are sort of still scratching our heads a bit. So, Sara, when the judge sentenced Kohberger, he said, quote, "Your 15 minutes of fame are over." But do you really think this is the last time we hear from him?
So interesting, Rich. No, I think the judge was obviously disgusted by the defendant that was before him, and he was sort of underscoring the fact that for months and 2 years, what I don't know, however many 3 years now, Kohberger made a big deal about cameras being on him in the courtroom. They should not face him a certain way, his eyebrows being bushy, all these things that were sort of, captured, he contested, and so I think he was sort of underscoring that with the 15 minutes of fame situation and sort of highlighting that he's nothing, he's done, like he's nothing, he's not important. But I don't think it's the last time we hear from him. I see this guy as an unremorseful, arrogant monster who will probably write a book because he thinks he's very academic and he's working on his PhD in criminology or whatnot. Docu-series, I don't know. I mean, there's going to be years and years ahead where obviously he's got nothing to do behind bars, where I think there's going to be materials and stories, whether they're true or not, that are going to come from him.
Okay. Well, Wednesday, I was also thinking about that plea agreement, and both of you mentioned it. Part of it was that he's not supposed to appeal, but Judge Hippler addressed that at the sentencing hearing, saying basically, you should consult with your attorney on that. Do you think that we see an appeal from Kohberger? And what would that mean for the death penalty? Does that go back on the table?
So, no, the death penalty was dismissed as the prosecution's obligation in that plea agreement. So you plead guilty to 4 murders and getting a life sentence for each of them without parole, and we will take the death penalty off. So that's that. But his right to appeal, even when you waive your right to appeal, there are some very limited circumstances that are not waivable. So, for example, if he discovered that the prosecution withheld evidence or that his lawyer was ineffective, I can't even imagine Ann Taylor, I think is her name, being accused of being ineffective in her, representation because she was so diligent. But if he makes a claim like that, or that he was under the influence at the time of the change of plea or something like that, then, those are sort of exceptions to that waiver, even if you've signed off on that waiver. So I don't see it happening here, Rich, but, anything's possible with Kohberger, I guess. Because like Safia said, he's a serial killer.
You don't know?
Yeah.
Anyway.
Well, Sara, Safia, I'm also curious about the idea of a plea deal. Does it truly give people closure? You kind of talked about this already, but that was sort of the message from the Latham County prosecutor and Judge Hippler. But we all know that the families, not all of the families at least, particularly the Gonzalez's family, felt the deal was not fair. So where do you see plea deals? Do you think it really actually gives people a sense of closure?
I think it depends on who you ask, right? Like in this case, for half the families, it was closure. They wanted to close the chapter, to close that book and move on with their lives. But for some people, it's not. It feels like this thing that was never resolved, right? And so it sort of depends on the family. It depends on the person whether or not this gives you closure.
Mm-hmm.
What do you think, Sarah?
I mean, I think, when you're looking for answers, why did he do this? Why did he show up? How did he, who was he targeting? But we wouldn't get any of that here because, first of all, according to law enforcement, they didn't find any connection. They didn't find any motive. Clearly, he was not going to take the stand and testify in this trial. So what we would get is a bunch of, forensic testimony, DNA materials, things of that sort, which is really a tremendous burden on the state and, the expense of it all. But doesn't really answer the family's questions. So I know they're upset, but if they really think this through, I mean, tell me if I'm wrong, Safia, but I think if they really think this through, they would be reliving this awful, crime against their children, but not really get the main answers that they're asking for, that they need.
So I think that I know the Gonzalez family, they wanted the death penalty. I think for them, closure was the death penalty. And if that trial was going to get them there, that's what they wanted. So even if they didn't know why, I think that they really were hoping that he was going to get the death penalty and he was going to die for what he did to their children. And even though I think they knew that the motivation wasn't there, I think they were very confident that a jury was going to convict him and that he was going to get the death penalty because this was just a horrendous, heinous crime. And I think that's what they wanted. They did not want him to continue living. They've said that. They've said, you get to live in a prison and read books and have your meals and everything, and our kid is gone. They never get to experience anything in life. So that's what I think is just really gnawing and hurting the families that are upset over this plea deal.
You're right with the death penalty, that they wanted the death penalty. That's another trial. I always say it is very expensive, Rich, to kill someone. It's very expensive. That is a very expensive trial for the state, and that's a separate trial. And, I don't know. I'm anti-death penalty, so I just don't see the point anyway. I think it's far worse for someone to be sitting there rotting in jail for the rest of their life than just being on an electric chair. I mean, it's a bad few moments, but then it's over. I just don't see the point. So, but anyway, the interesting case, I was looking forward to doing a daily serving justice on Kohberger, but
we were ready for it.
Yeah, we got our August back, so that's nice. Anyway, Rich, thanks for joining us. I hope you come back again. Safia, as always, thank you so much. And to our viewers, thanks for following along and tuning in to Serving Justice, where we dig into the defense on a weekly basis. Until next time, the defense rests.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.